now have with me Liborous Oshoma, a lawyer and public affairs analyst, as we discuss unending pre-election litigations in the country. Thank you very much for joining us tonight.
Yeah, my pleasure. Thank you.
All right. It's 58 days to the 2023 elections, and parties are still in court over election primaries. What exactly is going on?
Yeah, first and foremost, you have about 2 or 3 issues that are played here. One is personal ego. 2 is also at the core of it is our political parties really do not know how to play by the books. And so when they are forced to play by the books, the end of it is unending litigation. And then lastly, also is you can simply say they really do not understand the rule of the game. And so because it had always been the rule of the might, and now that they are all forced to comply with the rule of the game, with the introduction of an elaborate Section 84 of the Electoral Act, that also has created a lot of, more problem. Not that this is the first time we are having such number of pre-election matters. Consistently, we have always had, numbers of pre-election matters because of the ego of the politicians. Also, like I said, they don't want to play by the books. And, Section 84(14), empowers anybody who feels aggrieved to approach the court for redress. And that's what you see playing out here. And then you have factions of almost, at election, you see political parties are factionalized because also politics is the only guaranteed job in Nigeria today. So that's basically what's played out.
All right. I'm going to ask, is there any way we can have these cases dispensed with as quickly as possible?
Yeah, yes and no. Yes, in the sense that, yes, it's a good thing that some of the primaries, kicked off in earnest at early stage. So it gave, a whole lot of window to the court and the politicians to ventilate their grievances. And so most of the cases have been exhausted. Take the case of Delta State, had gone to the Supreme Court and, that had been dealt with at the pre-election stage for the PDP, but that of Edo State is still on. They've gone to Court of Appeal, they've gone to Supreme Court, and then back, and they are still on their way there again. So it is good that we start early, so there'll be time to clear, all of the pre-election matters that would have, arisen in the course of, the primaries. But also, our politicians need to change their attitude. That would generally put an end to all of this. If the rules are very clear and whatever happens, the courts is definite. There are no ways of cutting corners by the courts. The rules are not subject to myriad of interpretation, like what happened in Akwa Ibom State, where you saw one court, Court 6, the Federal High Court, Court 6, gave Akpabio mandate. Court 7 had the same matter, was seized of the same matter. Even though the rule says that the other party must be put on notice, Akpabio got an interim order, in another court, while there's a matter pending before, a sister court. So if the courts also are not, subject or amenable to different interpretation, and the rules are very as clear as they are now, and you get there, the court tells you, look, there's no need to dilly-dally. The rule is straight, go back and do it this way. I think that will also limit the number of pre-election matters, because we say the windmill of justice grinds slowly but surely, but consistently, like I have said, and I always say, we forget that justice delayed is justice denied. So if you know that you can always buy justice, then you always consistently, want to approach the court. Look at, lastly, INEC also need to put its foot down to ensure that when the processes are not followed, the court also had empowered, the rule now also has empowered INEC to send in reports that once INEC does not monitor, excuse me, then that the INEC report INEC shall issue a report. And so the court also had cause, like in Cross River State, had cause to look at the report, that was put in by INEC. So INEC also needs to ensure that they monitor these processes and reports are issued, and where these processes are not transparent, like the Akwa Ibom case with Barrister Mike Igini, reports are issued and they stand by it. When you do that, like we saw in post-election matters, it will also limit the number of pre- or post-election matters, because when the elections became a bit transparent, it discouraged politicians from going to contest the elections in court, because actually democracy should be the rule of the majority and not the rule of the majority through the court system. So these are ways we can also limit, the number of cases that get to court. But ultimately, the chips will rest on the shoulders of all of us to ensure that our electoral processes or electoral jurisprudence is elevated beyond where it is. And our attitude to election is not an attitude to election, is not a do or die thing, the way we currently operate.
Yes, you say our politicians play a bigger role based on egoism, but then critics say lawyers are partly to be blamed for all of this situation because some of them file frivolous cases. What's your view on this?
Yeah, I agree. I agree with you that there are some cases that shouldn't even be in court. In other jurisdictions, basically, what happens is when some matters of that nature are filed, the Bar Association will come down heavily on such lawyers, and then the court also will sanction, such lawyers. But here, anything goes. We have, lawyers of anything goes. Unlike Justice Kayode Shaw of blessed memory, JS, as he then was, once said, when there is allegation of corruption against a senior judge, then there are senior lawyers who are conveyor belts. So you have SAN on both sides. That is why, unfortunately, the position is so attractive and very lucrative today. So in every of such application, you have one SAN, 5 SAN this way, 10 SAN that way. So if some of these persons that file these frivolous applications, as straightforward as they are sanctioned, and then the politicians and the political parties also are sanctioned. It is not just the lawyers. Yes, it is good for the lawyer to advise, because you can advise and the politician. I've had cause to advise people. They'll tell me, look, this lawyer, you don't want to go to court. And then they move to the next lawyer. So it's about the money for some persons. But if both these politicians and the lawyers are sanctioned when such things happen, then also it will assist in going a long way. But in cases where the lawyer is strictly looking at the financial gain and counting the numbers, because also these are what will make you a senior advocate. How many of these cases actually get to court? So some of these pre-election matters are some of the cases that get to Supreme Court faster. How many criminal matters, how many civil matters do you still hear are determined at the Supreme Court or at the Court of Appeal level? Okay. Every day you hear, because these cases are time-bound, so they are the ones that go, faster to Court of Appeal and the Supreme Court. And so lawyers want these numbers to be able to attain the rank of silk. So, irrespective of what the facts are, irrespective of whether it is frivolous or not, the court entertain them. And so once you keep entertaining them, the impunity will reign supreme, and then, people will keep bringing them on until we devise a means to sanction both the lawyers and the politicians, come down heavily on some persons, and you definitely keep having that. Thanks for at least drawing my attention to that.
All right, going by all of this illustration, don't you think the whole essence of having primaries held so long before the general election has been defeated by these ongoing cases?
No, not at all. Not at all. Like I said, some of the primaries, some of the cases have been decided one way or the other, and the politicians now have time to face squarely the electorate and campaign vigorously. So when you have that window and you clear the backlog of cases, and then now you have opportunity to face the electorate. In the same vein, that's why we decide there's been this clamor for, hold election early. There's a window of 6 months within which to determine all the matters. And even though the elections are still holding late, between February and May will not be enough to clear out all the post-election matters. But at least it is a window, that we allow for some cases to be decided even before handing over. So when you have all of this, when you have enough time and window, it helps, it assists. So the cases that you have now are not still as much as the ones that you would have if the time was shorter. Look at the case of Kano that you referred to. Now, the court had, ruled one way or the other. And so if the time were not there, some of these cases will end up becoming academic exercise. Some of them would have even taken oath of office before the outcome of the case will be determined. Look at the case of Zamfara. The APC governor then had, taken oath of office, had even performed some duties. Look at the case of Bayelsa. It was just at the nick of time, just, a day before swearing in. So that's why time, really is of the essence to determine all of these matters. So it was like, I would not agree that the holding primaries long before the election, is defeated. But because the attitude of, if you like, hold it 1 year before, there will still be pre-election matters, as long as we maintain this attitude, as long as there are no consequences for actions and inaction, as long as people will still interpret the rules to suit the whims and caprices of certain persons, as long as people's palm will still be greased, to bend the rules to their favor, you're still going to have pre-election matters.
All right. Thank you very much, Mr. Liborous Oshoma, lawyer and public affairs analyst. Thank you for coming on Politics Tonight as we briefly discussed on ending pre-election litigations in the country. Thank you very much for coming tonight.
My pleasure.